Donald Trump's defense has sent several discovery requests over to Jack Smith and the prosecutors there at the deranged thug Prosecutors of America. And we know that they are responding with mostly declinations saying, oh, Trump, you need information for trial? We already gave you 13 million pages of irrelevant material, but you don't need this stuff because this stuff is actually pertinent. And so we're going to go through two examples of this. First one from the end of October. This is from Donald Trump's defense team. It's a request for discovery. Remember that the government holds all the cards. They have everything. All the files, all the videos, all the hard drives, all the data, all the law enforcement, all the money, everything. So the defense just says, can we please see some of it so we can prepare ourselves? Well, the government is going to reject them largely in both cases. The first one's going to come from Thomas Windom. He responds on November 3rd. The second request comes from Trump in mid-November. They get rejected about 10 days later by Molly. We know Molly, the highlighter girl, who says, I already gave you all your information and I made a nice little flow chart with sticky tabs in it. And the judge, Chutkin, was like, wow, this is beautiful. This is better than my kid's artwork that I shove on the refrigerator. So Molly is going to respond and reject. We've got two different rejections, and I want to share how this works because this is where a lot of cases are made, man. This is discovery. This is evidence. And we try to get evidence in, we try to preclude evidence. And so this is the stuff that is often not seen in a trial, but it's how we get to the trial. It really is the determination of what we talk about. It's all happening in these letters. And so let's get right to it. The first discovery request came out October 23rd from Lauro and Singer. This is Trump's defense team, and you can see it's a good one. It's a 10-pager. He says, all right, we're writing here from Florida and New York, laurosinger.com. Shout out to those guys. They send this over to Molly, highlighter girl, and Thomas, both of whom have a strong history of anti-Trump bias, right? Before this indictment was even filed, we know that they were sending letters to Bill Barr like, there's no election fraud. You're like, it's like November 10th, like the election just finished yesterday. How do you know that? I'm like, well, because we hate Trump. Biden won. Okay? Okay. So they say, all right, Trump's defense says, hey, Molly, hey, Thomas, we're writing on behalf of Trump. And as you know, we're entitled to Brady material and other things. We have a right to get it. Brady material under the Fifth Amendment, Sixth Amendments, and so on. Now, you people simply pointing to your voluminous discovery, and just to point out that they had 13 million pages of documents that they dumped over to the Trump defense team, and they said you've got about 9 months to review it, or however long, like less than a year to review it because trial's in March. 13 million pages. And we also saw that in cases like Walmart versus Visa, the defense found this case, it took 6 to 7 years, and there was only 7 million pages of documents in that one. Walmart versus Visa, whatever, it's an order of magnitude smaller. 7 years. So like 9 months, less than a year for 13 million pages. And they just say, when you say, can we have more information, please, about the actual stuff that we need? Molly just says, you got 13 million pages. It's all there. They say simply referring to that is not satisfaction of your obligations. Now, stop with this nonsense saying that you've exceeded your discovery obligations, right? You have not. We respectfully request that you actually produce discovery that is responsive to these discrete requests. We have specific things that we want. And I'm sure this is not the first one, okay? There are many more that came before this, but we're just picking two of the more recents. Now they say, all right, listen, Molly and Thomas. Now, each of the requests set forth calls for the production of documents irrespective of their classification level, okay? We want everything. So don't give us the non-classified, all of it. As used herein, the term foreign influence means anything as we say, and this is what we want. This request call for the specified documents as we define that term previously to you. So here's what they want. Please provide all documents about informants, cooperators, undercover agents, representatives, anyone acting at the behest of the DOJ and law enforcement agencies. Please provide all documents, cooperators, agents, and people who were there on January 6th. Now, a lot of this stuff is mirroring the motion to compel that we've already read through, right? The motion to compel is on the back of this. So these are all the original requests that they said, hey, like we're asking nicely, and then we don't get it. We get a motion to compel later. So some of this language is going to sound a little bit repetitive here, but it's for good cause. Now they say, please identify all consideration of things for anybody who is trespassing. Okay, so anybody who is given something for being physically present at the Capitol or for trespassing, like an exchange of goods. Now, please provide all documents about requests for national security at the Ellipse rally. Please provide any information about alternate electors used in prior elections that you guys know about and your investigations about those alternate electors, because we know that's happened in many other elections. Like 2020 was not the most recent one where we had alternate electors. Obviously, there was before that. So they investigated all the ones from 2016, right? Now, please provide all documents about state legislature involvement, approval, and acquiescence to alternate electors in any election. And we're going to see what the government responds. They're going to respond to each one of these. Now, please provide all legal opinions about state legislators and alternate electors, any documents about election fraud, fraud, including but not limited to 2020. Now, they also want this bunch of redactions here. These paragraphs, don't know what those are, but B, C, D, all the way through H, redacted. We've also got, they want documents, all of them, related to the investigation of voting anomalies, any irregularities in 2020, including but not limited to the number of total votes that exceed the past elections, anything like this, significant late shifts in voting totals, like we saw the little markings go. Remember we were watching the ballots, the returns come in, and it was looking like Trump was like this, he was like winning, and Joe Biden was like this, he was losing. And then all of a sudden we went to bed like right here, we're like, wow, that's pretty good, that looks pretty great. We were live streaming at the time, we're like, yeah, it looks like Trump won everywhere, it's pretty amazing. And then, figures, because nobody likes Joe Biden, it's weird, he's, a plagiarist and, dementia even on the campaign trail, so it's bizarre. But okay, so we went to bed and then we woke up, and then the next morning it was like this, like that. And we woke up and it was like this, Joe Biden wins. We go, well, that's weird. That doesn't look like, I'm not a statistician, but that looked a little bit strange. We saw that happening all over the place, and there was like water main breaks, and it was just really weird. And then all of a sudden, people started saying that looks like a big F, like the word fraud, because that's what it was. So they want information about that, right? Late night shifts and stuff. They want documents about anything that was provided to Trump and his advisors between November 3rd and January 6th about fraud, irregularities, and the other things. Documents regarding changes or amendments to state election statutes. And we spent, I can't tell you how much time here talking about that specifically about all the election litigation. We had charts, created about this stuff. So there's a lot of them. Documents about activities or responses by state legislatures following the investigations. All assessments of potential fraud. They say, please provide all documents about complaints or concerns by any prosecutor from the DOJ, right? Is anybody there like blowing the whistle? Is anybody there upset by what you're doing here? They also want any complaints by federal law enforcement, anything related to the 2020 election or the investigations that have been occurring. So the government's going to dismiss a lot of this. Watch. Now, please provide all documents about the DOJ personnel or the public integrity section. Any documents that show that there was no fraud at the trial at 2020. Any documents that accept the non-outcome of non-determination of fraud. Okay, and so look, a lot of requests here. Now, I'm not going to belabor ourselves and go through every single one of them, but you see here, paragraph 32, bunch of redacted things. Can we have that? Can we have that? Can we have that? Can we have that? Can we have that, please? All documents about improper FISA. Please provide documents about communications between the DOJ criminal, DOJ Office of Inspector General, Trump, Jeffrey Clark, and 2020 election. Information from NARA. Stuff about executive privilege. Whatever this redacted section is. All documents related to the transfer of materials between the special counsel's office and the House so-called select committee led by Cheney and Kinzinger. Similarly, redacted. What is that? All documents about election security issues, and so it's a big request, right? A lot of stuff there. They say, all right, John Lauro signed this off. Please confirm that you've done all of this. We expect to submit additional questions. So get started on this one, and another one's coming later. We're going to be submitting this on a rolling basis. Please let us know if you have any issues you'd like to discuss. Respectfully submitted, your friend, John Lauro. So that gets sent over. Now, the government responds. This is the one in response. This is Thomas Windom from the special counsel's office. Lots shorter than the other one. He says, all right, dear Trump lawyer, we write to your discovery letter dated October 23rd, the one that we just read, in which you make 79 discrete requests for discovery. And I was thinking to myself, 79? What? I thought I counted 50 something over here. There were 59 over here. And so then my thought was, oh, well, some of these have multiple requests in them. So Thomas sat down, probably with Molly, and they had a highlighter contest, and they counted every single question, right? So they went through and they said, well, these are not all discrete questions. And they counted this one. Oh, that's another one. So 37 plus 1, right, is that one. 37 plus 2. So they counted them. And so they counted all the sub-questions. Oh, that's one. And that's one. And so on, right? All of the sub-requests. And so it's not 59, actually. Thomas Windom and the rest of them, they counted them. It's 79. This is what lawyers do. As an initial matter, we previously rejected the definition of your so-called prosecution team that you attempted to impose on your October 15th letter. If you want to see more about that, we'll tell you. Look at our prior letter to you. And we need to know this, right? Who is involved in the prosecution team? Because it sounds like everybody is. Like they got info from Liz Cheney's January 6th Select Committee with Benny Thompson and the rest of them. They got info from NARA. They got info from the DC office, FBI field office over there in Washington. They have information from the CIA, allegedly, right? Certainly the FBI. Who's on the special counsel's team? Isn't the special counsel supposed to be a special counsel? Supposedly independent, kind of separated from the DOJ? They do their own due diligence and then come to their own charging decisions and conclusions? Or not? Can they just just gobble up all of the worst anti-Trump factions of the US government, cobble them into one, and then call it a day. That's what they've done. So Trump wants to expand the hula hoop and say it includes everybody, and they don't. They want to limit it and make it very small like that. So it's just, kind of looks like a donut or Judge Engeron. Now, here, the vast majority of the expansive requests, they say, in your October 23rd letter are deficient. Many of your requests seek information that exceed the scope of the government's discovery obligations. It's not even in our possession. We don't even have it. Other requests seek information that has already been produced as reflected in the detailed source logs accompanying each of our productions, as would be evident if you just search for them. Just search for them. Now, some requests, she says, the ones that we just read through, some of the requests are too vague for us to discern with particularity what you are requesting. We're too dumb. We're dumb prosecutors. We don't know. Still, other requests follow up on documents that we produced in excess of our discovery obligations, as in the 13 million pages that we dumped on your backyard. Now, to the extent that we produce or have produced information that is responsive to your discovery request, that production does not imply that we concede that the information is discoverable. Oh my gosh. So she says, look, we got 13 million pages of stuff that we dumped in your house. And if we included, she says, first of all, you don't deserve any of that information, right? This is a typical prosecutor's letter. Who wrote this? Is this Windom? Who wrote this letter? Let's see here. Yeah, it's Windom. All right. So he says a bunch of stuff. Yeah. Okay. So he says a bunch of things. First, if you did your own searches of the data, idiots, you'd find it. But if you find something that you shouldn't have, we don't concede, doesn't imply that we concede that you should have it as part of our obligations to give it to you. So we might have accidentally just included it. And if we accidentally included it, doesn't mean you're entitled to it. So don't ask for it. And if you ask for it, please be more specific because we're too dumb to understand what you've asked for now. All right. So notwithstanding the above, they say, to the extent that the following requests call for information that is discoverable and in possession of our team, we have produced that information already or will produce it consistent with the orders. And furthermore, we seek information to better understand some of your requests. In particular, the requests do not appear for call for the production of material, and so please explain your theory of discoverability. Your requests are so vague that we're not exactly sure what you seek. Please clarify. So in order to assist our job, here are things that might be responsive to you. Redacted, 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 redacted. Pursuant to the scheduling order, redacted, redacted here. Now, as noted in the August 11th letter, our first discovery production does contain transcripts and exhibits from witness testimony that we presented to the grand jury. We also have source logs and other grand jury transcripts which have already been given to you. This is redacted, 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 redacted. They say Trump was a party to 5 miscellaneous matters about executive privilege. Those filings are attached, and these are also redacted. Now, I don't know what they're really saying here. It says here, you appear to be requesting Giglio information. To the extent we've not already provided it, we'll provide it later. You request an explanation of unredacted copy of these records. If you have a question, let us know specifically what you want. It says the government maintains that we have consistently obliged and complied with the Justice Department manual, and we understand our discovery obligations and we're going to comply with them. So don't lecture us. Signed, Thomas Windom. We stand ready to confer with you if you have any other questions. Okay. So in other words, a lot of this is like, you've already got it. We're not giving it to you. Please see our opposition. We've given you some things, the stuff that you're entitled to, you've already got. The stuff that you still need, you're going to get. But search for yourself and go through your records, right? That's the first example. Now, we've got another example because they sent a follow-up to that a couple days later. About 2 weeks later, they sent on 11/15 a new letter back over to the government prosecutors. They say on the 15th says, all right, Molly and Thomas, your recent filings in court indicate that you plan to present evidence about the J6 protesters and the Capitol. They say this is strange because we do not believe that there is any evidence that is relevant to the charges in this case, saying that what you're doing here is extremely prejudicial and it's only going to inflame and confuse the jury. But nonetheless, we must be prepared to defend against these uncharged accusations. And so if you're going to talk about J6, well, we're going to need additional discovery. Now, please do not take this request as an indication that we believe any evidence that is related to January 6th is relevant and admissible. We're not saying that you can use it, but we are going to have to review it so that when you make your argument, we're prepared to object. So they say, as an initial matter, government, please let us know what aspects of the J6 events you assert are most relevant to evidence that is going to be introduced at trial. Because most actions questions at the Capitol on J6 are outside of the indictment, we ask you to identify the scope of your trial presentation so that we may conduct discovery accordingly. Now, in our October 23rd letter, the one that we read, we requested information related to the J6 protest, including information about undercover operatives, prior bids for security, National Guard assistance, 302s, memoranda about the J6 investigations, and so on. And below, we've got some additional requests for J6 stuff as you discuss the scope of your trial. Now, as our motion to compel deadline is approaching, we must get your position, and we know that that motion was filed basically subsequently with this. But they tell us, here's the background, and here are our requests. First, your response to our October 23rd letter, the one that we just read, which basically said you can't have much of this, did not clarify your position on relevancy with respect to each one of these things. Therefore, please clarify. If you intend to introduce evidence of trial of injuries that was sustained to law enforcement, please provide the documents about those injuries. If you think that you're going to introduce information about the Ellipse rally, can you please introduce and tell us about the military intelligence that you have? Give us all memos about interviews with law enforcement officers that were there at the Ellipse rally. Please provide all documents about the National Guard at the Ellipse, all documents about the sergeant at arms in the House of Representatives, who had operational control. Paragraph 8, redacted. Please provide information about Mayor Muriel Bowser's preparations and DC Metro Police preparations. All things that were done by the Capitol Police, permits that were issued, video of the J6 protest, anything that you intend to introduce at trial. We have the right to additional video once you've identified the video. So if you're going to do little Liz Cheney's highlight reel in court, we're going to go get the corresponding videos. Please provide all documents about efforts by foreign actors, whether state or non-state, to undermine public faith in the U.S. democratic process pursuant to intelligence reports. All documents about the alleged pipe bomber at the RNC and DNC, information about immunity that was granted to any persons who were charged, intelligence about activities of persons associated with Antifa, also Antifa. Ooh, they want to know, and information about Ray Epps, the scaffold commander, John Nichols, or any person who participated in this. They want the Norfolk memo, documents about December 20th preparations, congressional debates, daily intelligence reports for the rallies, more documents about operating procedures, communications, this is a good one, between Yogananda Pittman, Nancy Pelosi, Pelosi's staff, and Pelosi's representatives. All this information they want. Please provide us a memo of all the witnesses you expect to call at the trial, anything related to January 6th, violence, and so forth at the Capitol. Sincerely, your friend John Lauro, sent over to the government. Now, Molly responds to this one. She says, I don't know, John. Dear John Lauro, Molly says, we write in response to your November 15th letter, and to follow up, sounds like they had a meeting on November 21st. She sent this one a couple days later. She says, as an initial matter, John, during your discussion, our discussion together, you clarified that your questions about the scope of the prosecution team concerned documents available to you as a result of Trump's case in Florida, as well as which law enforcement agencies worked on this investigation leading to this case. They say, first, as we already told you, we produce witness statements given by witnesses that are in the investigation leading to the Florida case where witnesses were already interviewed, have given it to you. If you believe that there are other records in Florida that you think may be discoverable in this case, then you can call us. For example, we respond below to the issue you raised with respect to a document that you characterized as related to Mike Pence. And second, law enforcement agencies that worked the investigation were the FBI, the DOJ, Office of the Inspector General, the National Archives, OIG, and the Postal Service. Now, turning next, John, to the enumerated questions in your letter, we provide specific responses below. The Bates numbers identified below are examples of ranges that contain documents responsive to your requests. Now, they are not an exhaustive list of where the production's responsive materials may be located, so you can go find it yourselves, but it might be located here. So they ask for all that stuff, and they say, here, it's probably in the 13 million pages somewhere in this range. Moreover, to the extent that we produce or have produced information, it doesn't imply that we concede that we are going to give you more of it. So here are the requests. 1. This question, request number 1, is asked for additional responses to your letter. It says, here are our responses. They said, you want information about SolarWinds and the cyber attack. You think it's relevant to this case, but we disagree. No SolarWinds for you. You also clarified that you were asking whether the government was withholding non-discoverable evidence of election fraud. We have not withheld evidence of election fraud in our possession. Now, they say about requests. You indicated that during the course of our meet and confer, you talked about SEPA. Now, we refer you to the government's motion to strike about the relevance and the discoverability of these materials. So you're not getting that that either. Regarding this request, you stated that you believed it would be relevant to this case if a state legislator disagreed with the state judges. We disagree, but in any event, we're not holding any material in our possession, right? So we don't have it. Now, about request 23, you stated that you're seeking any legal opinions about the validity of mail-in ballots and all the things. They said, well, to the extent that we have anything, we gave it to you. You wanted this stuff? Well, here's our question on that, all redacted. Now, for requests 30, 40, 42, 43, and 44, that information exceeds the scope of our discovery obligations, and it's not within the possession of our team, or it does not exist, right? This is why the scope of the prosecution is so important. They can just say we don't have it. It's outside of the scope. So Rule 48 seeks Jenks material. If we determine that we're calling these witnesses, we'll give you those emails. And Jenks materials are reports, information that government witnesses are relying upon. It's discoverable. As we stated previously, other requests, 54, 55, 58, 59, all of those, we understand, will continue to meet our discovery obligations. Now, next, in your most recent letter, you made a large number of requests related to January 6. Now, below, we're responding to these on a question-by-question basis. As we advised you, in the course of our investigation, we accessed certain materials within the database, the J6 database. We took into possession certain materials that we may rely on, and we produced them to you in discovery. Now, in our August letter, we already told you this, but we reiterate that now. Request number 2, redacted. Don't know what that means. Request number 3, in our meet and confer, you wanted intelligence related to the ellipse. But this request exceeds the scope of our obligations, and it's not within our possession. However, to the extent that there is information that we got from the Secret Service and others, we've given it to you. So we just don't have it, man. They don't have a lot. Now, we produced interview reports and transcripts of law enforcement officers, and here are the people that we've given to you. So these people they've already produced reports on. And these requests seek information, here, a lot of requests, 5 through 7, 9 through 11, 28, 30 through 33. These requests exceed the scope of the government's discovery obligations. But if we had anything, we gave it to you. This one, we refer you to this motion. We don't think it's relevant. 12 exceeds the scope, not within our possession. We will identify trial exhibits under 13, 15 through 19, 34 through 36. All of these requests about the pipe bomber and Antifa appear to be focused on others' actions during the J6 attempts. And so none of this stuff is relevant here. To the extent that we possess any materials that you want, we don't have them. And so you stated that you think the DOJ has taken inconsistent positions, but we don't agree with that. We disagree. The DOJ's position is consistent, and Trump is responsible just like the other people were responsible. So this also exceeds the scope, and we don't know how to respond to this. Please give us some more information. And here it says, during our call, you mentioned that there were some technological glitches in previous document productions. As stated, and as we've previously offered, we will gladly arrange a phone call with our tech support staff to help. All right, so that's Molly, highlighter girl. And as you can see, they're still battling over discovery, and the motion to compel is now situated in Judge Chutkan's courtroom. And so we'll be waiting for an ultimate ruling on this, because this was the more recent response, November 25th. We're battling for discovery. What can Trump talk about as it relates to January 6th? It's a January 6th case. Hopefully Trump can get some January 6th evidence so that he can prepare his defense. We'll know that the government is going to do their best to stop him from getting access to actual evidence. They'll dump 13 million pages of materials that are more or less relevant, but the stuff that you actually need to prepare your defense, they're going to try to drag their feet on that. It's not in our possession. Who has it? The CIA? Can we get it from them? They're not within the scope of our prosecution team. So we'll be here, my friends, continuing to cover this. We'll see what Judge Chutkan says in her ruling. Thank you for subscribing wherever it is you're watching this. We go live at 5 p.m. Eastern time every day of the week. We look forward to seeing you here when we go live. And thank you for inviting someone from your friends or from your family to come and join us. We'll look forward to seeing you and them right back here on the next one.